Breaking news out of California in the case of Duncan versus Bonta dealing with the ban on so-called large capacity magazines. The state of California has filed another brief trying to justify how they can take away Californians' right to keep and bear arms, specifically by banning these magazines. They are not able to do it. I have read their brief. I'm going to bring you the details in just 1 second. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, a constitutional attorney, member of the United States Supreme Court Bar, and New York Times bestselling author. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so. Show your love for our Constitution. All right, folks, breaking news. I have in front of me the brief in Duncan versus Bonta that was just submitted by the state of California explaining why they get to put you in prison in California if you have a so-called large capacity magazine, which, as you know, is really a political propaganda term for a standard capacity magazine that holds 10 or more rounds. Okay, good news that this brief submitted to Judge Roger Benitez in the Duncan versus Bonta case, in my view, is not strong. So I'm going to quickly go through this brief because I want to make sure this is out there. The reason why their arguments fail, okay, I could probably distinguish and blow up every ampersand and every comma and every semicolon in this brief, but I'm not going to do that. I'm going to hit the highlights here, more than enough, in my view, to defeat this brief and to defeat the so-called large capacity magazine ban in California just by this review here, although I'm sure the lawyers in California are excellent and doing a great job on our behalf, so I'm not particularly worried about that, but I still want to make sure that, as I see it, the major arguments are addressed in this case, and you understand why California's brief in this case of Duncan versus Bonta fails. Let me go down the list right off the top. Number one. On page number 1, they like to remind Judge Benitez this is a penal code violation. If you have one of these magazines, this is actually good for us. The reason why this is good for us is several years ago, in a related case, Judge Benitez actually quoted and cited to me an article I wrote in the Harvard Journal of Law and Public Policy, and he specifically quoted me on the notion that you have a criminal statute in California that puts people in prison for a victimless, malum prohibitum crime that has no moral component, right? There's no fraud, murder, rape, robbery associated with this. It is a mere possession crime. It is defined as a crime simply by the whim of California state legislators and nothing more. And yet you can go to prison and lose your rights and lose your money and lose all sorts of things, including your right to keep and bear arms for life, if you run afoul of this. Now, Judge Benitez quoted me extensively of how this is totally wrong and unacceptable. And, hopefully I'm sure he's not forgotten that point. But the fact that California decides to lead off in the very first sentence of their brief, the California Penal Code, section 23301, specifically talking about this, reminds Judge Benitez that we're dealing with literally putting people in prison if you run afoul of this. This is not a fine. This is not a tax. Number 2 is California, again, pretends or does the best they can. I think their lawyers are doing the best they can, but they simply have ignored the fact that the relevant test as to whether or not an arm is protected under the Second Amendment is the Heller test of in common use, and I want to be very clear about this. If an arm is in common use today, and in common use, by the way, according to the U.S. Supreme Court, means mere possession for lawful purposes. And you'll see why that's important in 1 second. So here you have the state of California is trying to say that the relevant standard is the Bruin standard and trying to force Judge Benitez to redo all this argument, all this analysis under the Bruin standard, they claim, requiring the judge and the plaintiff's lawyers in support of the Second Amendment to try to find these historical analogs or argue about historical analogs. This is totally unnecessary. The reason why this is unnecessary is because in the Heller Supreme Court case and the Caetano Supreme Court case, the United States Supreme Court has already done effectively the Bruin methodology to teach us how to apply text, history, and tradition in the context of when a government tries to ban the possession of an arm. In Heller, they dealt with the ban of a possession of handguns, and the Supreme Court says handguns are ubiquitous. They're possessed for lawful purposes by millions of Americans. That's enough for them to be in common use. You can't ban them. D.C. cannot ban them. So the fact that the California is trying to get Judge Benitez to redo the work of the Supreme Court in Heller and Caetano, it's not going to work. The only question that is presented is, has the government, and remember the burden is on the government, the only question is, has the government of California demonstrated that these magazines that hold more than 10 rounds are not in common use for lawful purposes by Americans. There is no doubt they are. There's hundreds of millions of these out there. That is like a given fact. The next point I want to make is California, again, is trying to play games here. They are citing to two historical analogs. Specifically, they talk about gunpowder regulations. Now, I want to pause for one moment and make this very clear. It's a very simple way to distinguish this, but I want you to pause and think about this for 1 second. At the time of our founding, there were cities that had certain restrictions on how you could store black powder that was necessary to fire firearms. Boston had some of these. New York had some of these. These, to the extent you even consider these black powder storage regulations at the time of the founding, they do not meet the Bruin test of how and why historical analogs exist today. Remember, again, for banned cases, you don't need to do this, but I'm going to do it anyway for the academic exercise. Even if you want to assume, for the sake of argument, that we should analyze these founding era restrictions on how you store black powder, specifically that black powder storage had to be outside of the city, I believe in particularly, these brick large magazine type storage facilities. The reason why, and this is the key, the reason why the founding generation had these restrictions on black powder had nothing to do with gun control. It had nothing to do with arms control. It had nothing to do with crime or anything of the sort. It had everything to do, these were fire code, fire safety considerations, because all the cities at the time of our founding were basically made of wood and wood products. So if you put a magazine storage facility for highly flammable black powder in the middle of these cities, and that heaven forbid they caught fire, you literally would burn down the entire city of Boston in a day, or the entire city of New York. In fact, this exact sort of thing happened in London. There's the Great Fire of London that occurred where the entire city of London got burned down in a fire. So fire was an issue at the time of our founding because everything was made of wood. So obviously the why of these historical laws was a fire consideration, had nothing to do with gun control, and therefore fire regulations at the time of the founding, in the same way that hunting regulations at the time of our founding has nothing to do with justifying a 21st century gun control law, because the why they existed at the time of the founding is dramatically different than the why the anti-gunners are trying to restrict these magazines today, which has nothing to do with fire and everything to do with restricting access to firearms and the use of firearms in the United States. So then California goes on to talk about so-called trap guns. This is going absolutely nowhere, but it's the best they could do. They point out that at the time of our founding, going back into England, you had certain restrictions on the use of trap guns. Now, to make it really quick, there are two types of trap guns as a general matter. You have trap guns that people would sometimes put in their homes, where they would line up a firearm, and that if a criminal or an intruder opened up a door to break in when they weren't home, well, guess what would happen? The gun would go off and they would be killed, and they couldn't rob the place or steal from them. Likewise, you had trap guns for game, which was illegal in many places because it was viewed as a form of poaching. The use of trap guns for the purposes of setting them up and shooting intruders or shooting game when you weren't supposed to is dramatically different than gun control laws like the ban on magazines today, because nothing prevented you from owning trap guns or from owning the materials or the equipment that went into trap guns. You could own this. You could do all sorts of things with this. You just could not use it as a trap gun to either hunt in certain places or as a trap gun to shoot villains that were trying to break into your barn or whatnot. That was not allowed because it was too dangerous, because you couldn't draw the distinction between good and bad people. And they said, no, you can't do that. Again, nothing prevented you from possessing it yourself. You just couldn't stick it out in the middle of nowhere by itself with no supervision and let it shoot whatever came in the way. But that is dramatically different than these magazine bans that California has, that says that I'm not allowed to possess these magazines and keep them in my closet. I go to prison if I do that in California under the law as written, and that is dramatically different than the use of trap guns either in the founding era in America or in England. So again, it's not an appropriate historical analog, but again, none of this matters, because the only test is, are these magazines are they in common use by Americans for lawful purpose? Now, this goes to the next point I want to make, the fourth point, which is California, again, is trying to play this game. Now, I warned you about this game. The anti-gunners are trying to take the in common use test, which means that a firearm or an arm, whether it be stun guns, arms, magazines, ammunition, doesn't matter, that an arm is in common use for lawful purposes by Americans. They're trying to argue that in the Bruin decision, which talked all about self-defense, that in common use test in Heller was modified by Bruin. And what the anti-gunners are trying to say is that the burden is on the pro-gun movement, which is not true because the burden is always on the government, but set that issue aside. They're trying to say that the burden on the pro-Second Amendment movement is to show that these magazines that hold more than 10 rounds, or AR-15s for that matter, or AK-47s for that matter, are in common use by Americans for self-defense. And then the anti-gunners take that false assumption, but that's what they say, and then they say that there's just not enough evidence that AR-15s and or AR-15s with more than 10 rounds are needed for self-defense or are used for self-defense. It's very rare, and therefore we can't meet the in common use for self-defense test. But again, several problems with that argument. California is making this argument again. It's not going to fly for several reasons. The first is the test of Heller. It's still good law. Nothing about Bruin modified the Heller test that says if a firearm is in, or if an arm is in common use for lawful purposes by Americans, it's protected, period, full stop. It doesn't have to be just for self-defense. It could be for any and all lawful purposes. Self-defense is only one example. It could also be just because you want to use it, you want to possess it, you want to go hunting, you want it for recreation, for target practice. It doesn't matter. Any of these things are perfectly fine. Heller said it, the Heller dissent said it, Caetano said it, and so on and so on. What they're trying to say, and the reason why, remember, Bruin talks about self-defense, is simply because the issue presented in the Bruin case was where the two plaintiffs that sued who wanted to be able to carry a gun with a license under New York law, they wanted to carry a gun in public for the purposes of self-defense. And as a consequence, the Supreme Court in Bruin talked all about self-defense because the two plaintiffs in Bruin were not trying to get a firearm license or a carry license to hunt or target shoot. They specifically were asking for a carry license for self-defense. So the Supreme Court, in writing their decision in Bruin, obviously had to talk about the right to keep arms for self-defense because that was a specific issue presented. But nothing about the Bruin decision dealing with those facts in that case had anything to do with modifying or shrinking or narrowing the scope of the in common use test articulated by Heller and then again by Caetano. And again, Bruin cites to Heller favorably, so Heller remains perfectly good law. It is the law of the land when you deal with an arms ban case, arms possession ban case, which again, banning people from being able to possess and use magazines that hold more than 10 rounds in California is clearly an arms ban case. The in common use test applies, and these arguments advanced by California in this brief in Duncan versus Bonta should fail. The last point I want to make here about California's argument as to why it's going to fail in Duncan versus Bonta dealing with large capacity magazine is that they're trying to argue that, quote, post-reconstruction laws are relevant. Okay, this is a game for many reasons. As you know, for the purpose of the Second Amendment, there's kind of two periods that often get debated. For the purpose of the Second Amendment today, the founding era, which is around 1791, which is when the Second Amendment was adopted and ratified by American people. And the question really is, as an originalist, is that what did the text of the Second Amendment mean at the time of the founding, and what did people understand could be done and couldn't be done at the time of the founding? The people adopted it. The anti-gunners in California trying to use late 19th century American law to say that if they can show gun control laws after the Civil War, those should be considered in construing and understand the scope of the protections of the Second Amendment. This is absolutely, completely wrong. I wrote an extensive article about this. One of my articles got published in the Harvard Journal of Law and Public Policy. I'll link to down below. I got other articles on this. This is extremely wrong and very important to get right, and I think our movement is getting this right, and I think we're winning in the courts on the point. But nevertheless, California tries to bring this up again. Remember, after the Civil War, you have more, you don't have a lot of gun control laws, by the way, but you do have more gun control laws after the Civil War, in part because you have parts of the country under military occupation in the South, so you get kind of an attempt to ban the former Confederates from having guns. You also have other, quirky things in Texas going on with, I think, former Union officers sit on the Texas Supreme Court and so on and so on. So there's a lot of quirky things going on that give rise to more gun control laws, and of course, there's an attempt to pass gun control laws to try to disarm the blacks. At the time after the Civil War, once they become freed, you have an attempt to try to disarm the blacks. You have the enactment of the Freeman Bureau to try to counter that. But the bottom line is there are more gun control laws after the Civil War in American life than there were at the time of the founding. So as a consequence, the anti-gunners are trying to use as many historical analogs as they can find because they want to uphold gun control law. So the anti-gunners try to say, if we can show gun control law at the time of the founding in 1791, we get to use those. And if we get to use any gun control laws after the Civil War, we, the anti-gunners, the Californians of the world, get to use those too to justify modern gun control laws. It cannot work. It's not appropriate because the relevant time period for interpreting the entire Bill of Rights, as the Supreme Court has said repeatedly, including the Second Amendment, 1791, the time of our founding, because again, that is the time when Americans adopted the Bill of Rights, adopted the Second Amendment, ratified it. So that's when the best time to look to see what gun control laws existed at the time of the Second Amendment, to see what would be considered a long-standing gun control law, what did the founders think the Second Amendment, because they're the ones that adopted it, so their view controls. Anything after the Civil War is way, way too late. The Supreme Court has repeatedly said this. They did have this sort of nod about a scholarly debate, which isn't much of a debate, as I pointed out in various articles. But the most thing you need to know here is the game that's being played. So what California writes here, they write, quote, pre-founding and post-reconstruction laws are relevant. Now, I just want to talk about post-reconstruction laws here. By post-reconstruction, again, they're talking about after the Civil War and after the Reconstruction period, but they're not relevant except in one example. So the anti-gunners are trying to say if we have anti-gun laws or gun control laws adopted after the Civil War, they get to use those to cut back on our rights today by justifying modern-day gun control laws are analogous to laws that existed after the Civil War. Okay, this is not true. But here's the nuance. I want to make sure this nuance comes across clearly. I want to be clear. It is technically true that American law after the Civil War, during the Reconstruction period, in the late 19th century, can be relevant to the Second Amendment, but not in the way the anti-gunners of California wants it to be. The way it works is this. You apply the text, history, and tradition test. The text of the Second Amendment first, and then the history. Now, the history you look to is the time period of 1791, the time of our founding. But here's the thing. To the extent that there's evidence after the founding that confirms, affirms, reaffirms the understanding of the Founding Fathers in the text of the Second Amendment in 1791, but that history or that tradition continues on continuously after the Civil War and beyond, that can be relevant. So to give you an example of this, at the time of our founding, it was illegal to use a firearm or any arm to commit murder. That was the law in 1791 at the time of the Second Amendment. The law against using arms of any sort, including guns, to commit murder has continued to this day. So in that example, if someone brought a Second Amendment challenge against like a murder statute, it would fail. And a reason why it would fail is because the laws of misusing firearms to commit murder have existed in 1791, but they continued through the Civil War period and after the Civil War and into the Reconstruction period and beyond. So in that particular hypothetical case I've just described, the post-Civil War history of America would be relevant because it would confirm or affirm or reconfirm the understanding of the Second Amendment as found by a court in 1791. The one thing, though, that the anti-gunners are trying to do, and California is trying to do, is not allowed. What they are trying to say is that to the extent that you had the right in 1791 to keep and bear arms in a particular way, but then if they can show a gun control law in the late 19th century that did not exist before 1791 and only came into existence after the Civil War, the anti-gunners claim that they can use that to reduce and narrow the scope of the Second Amendment as understood in 1791, but that is not allowed. Because the only time late 19th century American history and law is relevant is a one-way ratchet in favor of rights, in favor of liberty. Specifically, you can use the late 19th century laws and historical analogs to confirm the 1791 understanding of the Second Amendment. You cannot use late 19th century historical analogs or gun control laws to contradict or to shrink or to conflict with the 1791 understanding of the Second Amendment. Okay. All right, folks. Hope you learned a little bit something here about California's brief in Duncan versus Bonta, why I think it's going to fail. If you haven't subscribed to the Four Boxes Diner, please do so. And we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.